Okay, I think we're going to go ahead and at least get started with some introductions. And as folks join us, we have a team standing by to let people in the room. So I'm Pam Metzger. I direct the Deason Criminal Justice Reform Center at SMU Dedman School of Law in Dallas. And I'm so happy to have you all join us today for the first in our 2023 CJR Scholarship Series featuring Professor Sean Hill. We do this series, we're trying to do it once a month with a wide range of scholars, and we look for people who are thinking and working on criminal justice reform topics. So let me say a word first in introduction of the Deason Center. We have three primary areas of expertise. We think long and deeply about the delivery of public defender services and the ways in which people do or don't receive their constitutional right to counsel in the criminal courts of this country. We work on questions of prosecutorial charging discretion, thinking about how and when prosecutors make their charging decisions and what the downstream ramifications are of decisions that are either too fast, made too quickly, or made too slowly. And lastly, we're involved in an endeavor of thinking about what we call star communities, small tribal and rural criminal legal systems, and the ways in which their needs, their strengths, and their challenges are quite different from the ones that we talk about in our media, which are predominantly urban systems. And in that space, again, we concentrate primarily, almost exclusively, on the work of prosecutors and public defenders. Thematically, our work centers itself at the very earliest stages in the process. So how do people get lawyers? What happens after they're arrested? How long does it take to get to court? How long does it take to get a decision on whether you're going to be charged? And we think a lot as well about lawyer quality questions, caseloads, and what it means to give high quality legal services. So with that introduction, I think I'd like to go ahead, because it's 5 after the hour, and introduce today's featured guest. Professor Sean Hill joins us from the Ohio State. I'm going to be saying that, Doug, until the day I die. He joins us to talk about a work that would be timely at any point in this country, but it's particularly salient based on the events of the last several years. His work in general thinks about criminal justice reform and the intersection of race and policy in the criminal justice space. He is publishing in the UCLA Law Review, for example, about bail reform and pretrial risk assessments, again, with a critical race lens. And he comes to this with some deep experience in the actual work of criminal legal practice. He's been a staff attorney in a juvenile justice program. He's represented incarcerated youth. And he's thought a lot about, again, what the journey is from outside the system to in, and in many ways, what violence the system does. So with that, I'm going to hand it over to Professor Hill. He'll speak to us for about 15, 20 minutes. He's going to let us know how we can help him think about this exciting project. At the end of his presentation, I will moderate questions. You can either raise your hand and ask to unmute, or you can put questions in the chat. If you have your camera off while you're listening, I am going to come back and nag you to put it on when we get to the discussion, because everybody on here knows how badly it sucks to have to talk to a screen of black squares or pictures. Not fun. And then we'll wrap up once again by checking in with Professor Hill and seeing whether he has any additional questions for us. So with that, Sean, take it away. The floor is yours.
All right, thank you so much for that introduction. It's a pleasure to see all of you. I'm going to quickly share my screen. Okay, and hopefully you all are seeing a PowerPoint. So to preface my remarks, I'd first like to point out where I would appreciate feedback in particular. Of course, welcome all feedback. But what you'll note is that first, I'm covering a lot of terrain in this piece. So it would be great to know what's not sounding as persuasive, what's especially convincing, what you think might be worthy of being dropped in order to dig into something else more deeply. And then second, I don't know if I want to use the social contract as my launching point any longer. I still think it's deeply relevant, but I'm just contemplating maybe shifting focus from the social contract itself to what really constitutes a legal right. And I'll be talking about that in today's remarks, but really just kind of spending time thinking through what's a right, particularly in relationship to critical theory. So feedback on that front, if you think maybe the social contract piece can be left off in favor of this focus on a legal right, that would be helpful. Okay, so my intention is to speak for about 20 minutes. I'm going to try to make sure I'm keeping track of time myself. And again, thank you so much for your feedback. All right, so we have a problem with violence in our country, yet there is widespread disagreement about just what that problem is. So let's take as just one example, the racial justice protests that have swept the nation in recent years, particularly following the murder of George Floyd by Derek Chauvin. Now, some commentators, both in and outside of the legal academy, have contended that these protests have driven increases in violent crime, specifically the rise in homicides over the last several years, that they have disincentivized officers from making arrests and prosecutors from pursuing criminal charges, and thus that these protests have contributed to a loss of collective safety. But for many other commentators, the protests shed a much needed spotlight on the continued vulnerability of non-white people to police violence. And rather than focus exclusively or primarily on the alleged increase in the crime rate, this particular set of commentators directs our attention to how the criminal legal system fails to protect minoritized communities from myriad forms of state violence. I believe that all these conceptions of violence, whether as an outgrowth of racial justice protests or as a distinct and persistent threat to minoritized people, I believe that these conceptions have not sufficiently accounted for two historical phenomena. So first is that violence committed by people who are classified as white has been integral to preserving our economic and racial order across time and place. And then the second phenomenon that I don't think receives sufficient attention is that multiple institutions, not just courts, but state and federal legislatures, along with law enforcement, ensure that this violence evades prosecution, regardless of whether the perpetrator is a civilian or acting under color of law. So when we account for these phenomena, it becomes evident that the state does not guarantee safety and protection regardless of race, nor does the state have a monopoly on violence that it only occasionally relinquishes to private citizens, but rather we can best understand violence as a racially contingent legal right. This right is exercised and enforced according to the prevailing labor and racial order, and it is available to all persons classified as white, regardless of whether they are acting as a private citizen or under color of law. So I'll briefly touch upon the various forms that a legal right can take. Then I'll turn to the historical record to demonstrate how violence has assumed the shape of a legal right. I'll then discuss the implications of my theory in relation to two current events: legislation that prohibits the criminal prosecution of motorists who drive over protesters, what I'm calling vehicular violence legislation, and then the January 6th insurrection. Okay, so hopefully. All right, so just very quickly with regards to legal rights. So legal academics, political theorists have offered us various conceptions of rights, but I want to focus on two specific categories: positive versus negative rights. So negative rights are rights that protect fundamental freedoms or liberties from intrusion. They usually impose a negative duty on others, meaning a duty not to interfere with the person's activities in a certain area. We can think of something like the right to privacy might be conceived as a negative right. It places a duty on others, specifically the state, not to intrude into people's activities with exceptions. Positive rights, in contrast, represent a claim to something. They place a burden on the state to affirmatively fulfill certain obligations. We might think of these as a right to healthcare, a right to basic housing, or a right to education, where the state would have to fulfill something affirmatively. The distinction between negative and positive rights is not always clear, and there's often overlap between the two. So even though a negative right is supposed to entail non-interference, the state may have to affirmatively step in order to guarantee that type of non-interference. So property rights don't just protect the holder from encroachment. We also see the state take affirmative steps. It might generate processes for us to register that property, like by way of a deed, and it also establishes regimes for protecting that property. So negative rights can also come with affirmative obligations on the part of the state. When we examine case law and statutes of the past, it becomes evident that violence has taken the shape of both a negative and positive right throughout the country's history. And I articulate this right in the following way: that violence that enables and enforces the dominant position of persons classified as white shall evade punishment, subject to limited exceptions. If punishment is to be inflicted based on it falling into an exception, that punishment shall be less severe than the punishment that is customarily imposed for the underlying criminal offense. So it's important to note at the outset that this right of violence is longstanding, and it was not originally a race-based right, but rather a right that was contingent upon the religious identity of the parties. So in 1245, quite a long time ago, Pope Innocent IV published the Commentoria Doctrissima, which was a document that explicitly stated Christian invaders had a legal right to enslave and exterminate non-Christians, particularly indigenous people. This right was not exclusively available to Europeans or people who would later be classified as white. Rather, any person who converted to Christianity could exercise the right, including African and indigenous converts. Because the Catholic Church had conditioned violence and other rights on religious identity, it eventually confronted a distinct problem, which was that non-European converts were contesting settler colonialism, contesting the legitimacy of domination. There was a tension, in other words, between a narrative that non-Christians were irredeemable heathens on the one hand versus the reality of non-European converts engaging in conquest on behalf of the church, thereby demonstrating their humanity. So the English monarchy eventually distinguished itself from Catholic nations and surpassed these countries in profits drawn from slavery and settlement through the creation of whiteness. And this was a social construct that meant that a distinct category of people based on skin color and other morphological features could be treated as presumptive slaves. And it also generated cohesion amongst persons classified as white, regardless of religious or class differences. So this was this distinction between the English monarchy versus Catholic nations that first articulated this right of violence. Both before and after ratification of the Constitution, we see violence primarily taking shape as a positive right. Namely, colonial legislatures, followed by the National Congress, took affirmative steps to ensure that violence against non-white people would be excluded from punishment. So the first step was case law and statutes that established the ancestry and phenotype that were necessary for classification as white. The American jurisprudential system broke from English common law by conditioning one's status on the status of the mother, right? That slave status would be contingent upon the status of the mother. And then second, as the legislatures generated the conditions for racial classification, they also explicitly authorized and even required violence against non-white people. So in 1690, South Carolina passed the Act for the Better Ordering of Slaves, and that act required, quote, all persons under penalty of 40 shillings to arrest and chastise any slave out of his home plantation without a proper pass, end quote. In Virginia, which was home to the largest slave society in North America from 1705 through 1865, we see a series of acts passed in the 17th and 18th centuries that outright authorized white people to kill enslaved Black people. And then, of course, we have constitutional clauses that eventually guaranteed the persistence of slavery, like Article 1, which prohibited legislative interference in the slave trade until 1808. And these clauses represented affirmation of the right of violence in that they legitimated a racial order wherein every white person had the authority to brutalize persons classified as Black. So as violence is taking shape as a positive right through legislative measures, it's also taking shape as a negative right through criminal jurisprudence. Specifically, we see courts using the occasional criminal prosecution of white and enslaved defendants to dictate when the government could interfere in the right and when it could not. So the availability and suspension of the right, like its religious-based predecessor, turned on the labor needs of the possessor or dominant class. Namely, persons who directly profited from the labor of the enslaved person, like the plantation owner and his overseer, had the broadest authority to brutalize, torture, or kill. Writing in 1829, in the case of Mann, the North Carolina Supreme Court explained that, quote, full dominion of the slave master over the enslaved is essential to the value of slaves as property. And then it proceeded to acquit a white defendant for an assault upon an enslaved woman. Similarly, the right could be assigned to non-white people so long as their violence fortified the superior status reserved for persons classified as white or generated wealth for the slaver. So enslaved Black people who served as plantation overseers could brutalize and torture other enslaved people in the same fashion as white masters or overseers. And in a case like George v. State, decided by Mississippi's highest court in 1859, the court vacated the criminal conviction of an enslaved man for the rape of an enslaved woman, concluding that neither common law nor statute recognized the rape of an enslaved woman as a criminal offense. So those persons who were disconnected from the labor of an enslaved person could not invoke the right, nor could white masters who outright murdered or maimed the enslaved person, thereby obstructing the continued exploitation of their labor. So in a case like Commonwealth v. Carver, decided by Virginia's highest court in 1827, the court affirmed the conviction of a white defendant accused of shooting an enslaved man. And in the court's own words, quote, whatever power our laws may give to a master over his slave, it is as important for the interest of the former as for the safety of the latter that a stranger should not be permitted to exercise an unrestrained and lawless authority over him. The post-bellum period witnessed passage of the 13th and 14th Amendments. Of course, the 13th Amendment prohibited enslavement on the basis of ancestry. The 14th Amendment empowered the federal government to intervene in violence committed by white perpetrators. The language of the 13th Amendment, which prohibited involuntary servitude except as punishment for a crime, merely meant that states could no longer explicitly condition forced labor or violence upon a person's ancestry. Instead, labor exploitation would have to be preceded by criminal prosecution. We see state legislatures swiftly pass Black codes, which criminalize African Americans for both mundane activities and notably for failing to sign annual labor contracts with plantation, mill, or mine owners. So we continue to see this nexus between violence and the exploitation of labor. So while we have the post-bellum convict leasing system arising by way of Black codes, post-bellum convict leasing did not offer the scale of social control that was seen on antebellum plantations. Namely, African Americans who were not arrested could reject exploitative contracts. They could depart the South in search of better wages, both of which threatened the profits of white elites. So expanding the right of violence during the postbellum era, regardless of the parties' labor relationship, could solve the distinct issues that arose in the postbellum era. Namely, whites through collective acts of violence could intimidate African Americans into remaining on former plantations, and they could also repel outsiders, white or Black, from offering better employment opportunities outside of the South. So during this period, we see violence not being exclusively inflicted within the convict leasing system, but rather between 1877 and 1950, there were 4,000 racial terror lynchings in just 12 Southern states alone, Police-led violence was not exceptional, but common, with law enforcement leading white riots in Savannah in 1868, Baton Rouge in 1870, and Barber County, Alabama in 1874. So in these ways, violence continued to manifest as both a positive and negative right within the states themselves. It was positive in that state legislatures affirmatively passed Black codes, restricted voting rights, while the judiciary approved all white juries, excluded the testimony of Black witnesses. But it was negative as well in that multiple state officers, whether police, prosecutors, judges, local council members, refused to intervene following acts of collective white violence, assuring that this violence would remain beyond the reach of government interference. The federal Congress was acutely aware that state officers regularly participated in violence against formerly enslaved people, and this motivated the Congress to pass the Civil Rights Act of 1866, as well as the Enforcement Acts of 1870 and 1871. And these acts authorized federal prosecutors to pursue criminal charges against white defendants for obstructing or denying the legal rights of Black people. So the postbellum period is distinct in that the federal government temporarily abandoned its commitment to the right of violence, which meant that the Supreme Court would have to intervene in order to assure the right's persistence. So cases like Blyue versus United States v. Cruikshank, Screws v. United States, these represent that intervention on the part of the Supreme Court to assure that violence could proceed within the states themselves. So John Blyue and George Kennard were accused of murdering an entire Black family, and 2 surviving witnesses were prohibited from testifying against them, even in the wake of the Civil War, because Kentucky law continued to prohibit the testimony of Black witnesses against white defendants. Cruikshank, the case of Cruikshank arose from the Colfax Massacre of 1873, wherein a white mob killed over 60 people, mostly African Americans. And then the case of Screws involved a white sheriff, policeman, and special deputy beating an unarmed Black man to death. So following the trials at the federal level, trial court level, guilty verdicts were entered in all 3 of the cases, which the Supreme Court proceeded to overturn. Through this series of cases, the court was not only able to neutralize federal intervention, its jurisprudence also ensured that violence would remain a negative right beyond the reach of government interference. Guest and Price were decided about 20 years after Screws in 1966. They're pointed to as a suspension of the court's opposition to criminal liability under federal legislation. And I think that that is an accurate framing. But neither of the cases placed an affirmative obligation upon state nor federal prosecutors to respond to white violence. And so as a result, state officials continued throughout the 20th century to suspend investigations and prosecutions where violence was committed against Black victims. And at the federal level, the Department of Justice has never robustly enforced federal legislation pertaining to these forms of violence. Namely the figures that we have between 1979 and 1982, the Department of Justice each year between 1979 and 1982 has received between 10 and 11,000 complaints under the Enforcement Act. So these are people bringing claims that my rights have been denied on the basis of my racial identity or other protected status, 10 to 11,000 each year. In 1979, the DOJ prosecuted only 50 cases. In 1980, only 42. In 1981, 42 cases. 1982, about 56. Between 1980 and 1985, the department brought only 46 prosecutions for racial violence. The department has never pursued more than about 10 cases per year under Section 245 in particular. So ultimately, this points to, again, a lack of both affirmatively prosecuting, but also that this type of violence remains beyond the reach of government interference. So I'll finally end here. 2 recent phenomena indicate that this right remains intact. The rise in legislative bills that prohibit liability when drivers run over protesters, and the failure of law enforcement agencies to respond to the January 6th insurrection. So between May 2020 and September 2021, there were 139 recorded incidents of vehicular violence. These are incidents wherein drivers used their vehicles to strike or kill protesters. Charges were brought in only 65 cases, and only 4 drivers were convicted of a felony. In 2021 alone, legislators in 11 states introduced 18 new bills that would reduce or eliminate civil or criminal liability for drivers who run over protesters. Just 9 months after the Tulsa County in Oklahoma, after the district attorney's office announced last year that it would not pursue criminal charges against a driver who had struck several protesters, the Oklahoma legislature successfully enacted a law shielding drivers from both criminal and civil liability when injury or death occurs while, quote unquote, fleeing a riot. That same year, state officials in Florida and Iowa successfully enacted bills creating civil immunity for drivers who run over protesters. A bill is currently pending in the New Jersey Senate, which shields drivers from civil immunity as well upon proof that the victim sustained their injuries while acting in furtherance of a riot. So of the 13 states that sought to immunize drivers from civil or criminal immunity but failed, 8 succeeded in enacting legislation that criminalizes protests. So even if the civil or criminal immunity does not succeed, there has been an expansion in who is vulnerable to these forms of violence, particularly at protests. Finally, January 6th can supply insights into how the right of violence continues to manifest as a negative right. So some might point to the prosecution of January 6 rioters as evidence that the right of violence has been eliminated. 2,000 people who participated in the attack on the Capitol, about 900 have been charged with crimes. They are predominantly white. However, the right of violence has never been absolute. It can be suspended in select circumstances, but it still guarantees less severe punishment. And this phenomenon is evident when we compare the arrests and sentences imposed upon Black Lives Matter protesters to January 6th insurrectionists. So about 52 people were arrested the day of the January 6th insurrection. In contrast, when there was a protest, a racial justice protest at DC's Lafayette Park in June of 2020, even though that was dramatically smaller than the number of protesters that were at January 6th, there were 289 people who were arrested that day. In the year following George Floyd's death, more than 300 federal cases were opened against BLM protesters. 120 defendants have pled guilty or were convicted of trial. Over 70 of these defendants received prison sentences, with the average sentence being 27 months. Based on these figures, 58% of racial justice protesters received prison sentences compared to just 41% of January 6th rioters, and the average prison sentence for racial justice protesters was 8 times longer than sentences entered against insurrectionists. So ultimately, taken together, both the conduct in the wake of January 6th, the failures of law enforcement, despite multiple alerts, warnings, both from DHS as well as from local law enforcement, all of these concerns were ignored. And in these ways, violence remains intact as a positive and negative right. If we conceptualize the problem of violence in the ways that I'm recommending, we should at minimum rethink continued investments in the criminal legal system, and we should simultaneously re-examine how our institutions enable this violence, how the social compact within our country remains compromised in its exclusion of Black people from safety guarantees. So I'll end there. Thanks so much. I know that was quick. I look forward to your questions and comments.
Wow, Sean, thank you so much. And I'm going to remind people, I've asked you if you've been following along without your camera on, please do turn it on now. It's just awful having to speak to, pictures of still faces or words. So if you can turn your camera on, please do. I understand not everyone is in a position to do so, but if you can, please do. So thank you for that. I'm going to do as I threatened, which is take the moderator's privilege and say that you asked at the beginning what was most compelling and what was gripping. And I'm going to say that you started in the wrong place, in my opinion. The end was fascinating and gripping and is incredibly important. You've done a lot of really important empirical work analyzing these sentences, coming up with, I'm sure, a basis for how you can make them parallel. You've done a survey of the state legislatures and what's happening. I would love to see a chart of that. I would love to see a graph. I mean, there's some easy data visualizations, and if you need help with that, we got people here who I know would be happy to talk to you about it. If it were, what I would love to see you do is completely invert this. I would love to see you lead with, this is what's happening. then take a deviation into here's why. And I don't think you have to go as far back or as deep in the history as you do. This is my 2 cents. It's easy to go down that rabbit hole. I've been there. I once spent, I think, almost a year reading every Supreme Court case on confrontation. So because I wanted to prove that it was all coming out of anti-Mormon sentiment. Don't ask me why. That seemed like a good idea to research at the time. I never did anything with it. But my point is, it's easy to go there because it's so rich, but I think it's pulling away from your real contribution here. And if you're not careful, your very detailed and very important historical research will overwhelm what I believe is the much more important and much more salient evidence that violence, is being, as you put it at the beginning, as part of the social contract, right? A racialized, minoritized, kind of permissive violence being legalized. It is the most important point. I think I would hit it, and I would hit it hard, and live in that spot. And with that, I will see if anyone else wants to add anything on that before we open it up for other questions. I'm sure Doug warned you that I'm going to do this to you. He told you I was very shy. I just want to ask whether other people think I'm right about that, because I feel so strongly that if I'm wrong, I would like to hear. I'm just so impressed with the tail end of this paper, in particular. Jordan, you there? I think you have to ask. Here, you have to ask to unmute. Can somebody unmute? There she is.
There we go. Yay. I thought I had a ton me over here. Apparently I don't. Pam, nice to see you. And Professor Hill, Sean, thank you. So I love the energy. The way you started, it's like, oh, I just have a couple things. I'm like, no, you got a lot. Okay. So I put a lot of work into this. And I find it absolutely fascinating. But I have some other points, but just to respond to Pam's point, I agree absolutely. Yeah, I would start with the here, the now, the data. And I actually like the history part, but I also think that's good footnote fodder and, kind of that rounding out on the margins, whereas the core of your work and the importance of your work is exactly all the data you've come up with around the contemporary statistics and some of the more recent case analysis. So I just wanted to echo that thought. Thank you.
Doug, and then I think Kenneth Nunn. Take you in that order, because that's how I saw you.
Thanks, Pam. Good to see you. Thanks, Sean. Literally you're across the hall, I think. But yeah. In any event, nice to have this forum. I just want to kind of echo, but caution is the wrong word. I think the challenge is even doing the lining up of let's compare the January 6th defendants and folks sentenced for racial protests. That's candidly probably a lifelong project, let alone something that I think you want to be careful. And this is, again, sort of with the challenges. I think it's very important, very powerful. Will draw people in, especially because definitely on the right, there's a kind of widespread assertion of, oh, look how terribly they're being treated, relative to all the people who got away with it, in those violent protests. And so I think that's an important teaser that, again, how you unpack it can be debated. Same goes for, the right to protest and the driving through protest material. Again, that's a career-based project potentially. So I think it's finding the way to sort of say that's what this is a part of. I'm not sure I would keep all the history, but I do think history, if you can, kind of cover it quickly enough to say this is part of this big broad story. And here's where especially, I'm finding myself, and I think it's itself part of where you can kind of do a kind of different kind of homage to, hey, this new Supreme Court says we're supposed to go look at what was going on back at the framing. Okay, look at what was going on then, because I think that both gives a reason for the history and helps to illuminate, okay, if we're going to learn from history, let's not learn a sanitized version of, look how great we all were. Let's fully understand. And I think you know how caustic these conversations can be and how important it is to just say, look, these are observations that thread together in a way that is, kind of part of both our current existence, whether we recognize it or not, and our history. And so I think, but I totally get why the comments are, and I largely share them, tease people with the, this is what's going on today. And I'm going to now explain to you and highlight to you how it's part of this much longer narrative. And in fact, it makes it easier to understand. And for me, it would be both, not just that there's this disparity, but that we're kind of blind to it, right? I mean, I think you're doing the research. I don't see a lot of articles. I just Googled, the treatment of the January 6th rioters versus folks involved in the race stuff. And what you get is, it's not right that the Jan 6 folks are being treated so much worse. That's the framing already is like, let's explain to you why, they're not getting really, put under the thumb. And it's so, I just think it's such powerful stuff you're doing here. Thank you. And I'm glad you're in my midst. We can talk about this more whenever you want.
Yes, absolutely.
Appreciate that.
Thank
All
you.
right, one more person on this point, and then we'll see if Sean wants to respond, or we'll move on to other topics. All right, hands none, you're up.
Thanks, Pam. Sean, I really appreciated your bringing this idea to us to share with us. I think it's very powerful. And I actually agree with Douglas. I would push back on Pam's suggestion that the history is not important. I think the history is very important. I think that's probably the most beneficial contribution that you're making here is talking about where this division comes from. I was thinking of some other examples of that because, right now you're talking about the papal bull, but it just permeates a whole bunch of parts of American society. I was thinking about how we talk about the Winchester and the Colt 45 as the guns that won the West. And that's because people use them to suppress, indigenous people and to take their land. So there's a view though that that's part and parcel of what being an American is to have a weapon. And then that comes into this whole notion about the Second Amendment and why it's important and all of that. I think it all grows out of this notion that certain kinds of violence are acceptable if they're used to enhance white supremacy. But the other point that I think is that I think the framing that you give is a little disconcerting to me because I don't think that the people who are, say January 6th, participants, whatever, I don't think that they view, and I don't think that the criminal justice system as a whole views their actions as violence. They're not violent. They are not rioters. The rioters is a racialized term. And we know who, comes to mind when we start talking about who's rioting and who's not. So I'm not sure, this is getting to another issue, and this is the first question you asked about, which is whether you want to talk about it as a social contract or as a right. And I'm not sure that a right is the right framing here because it really isn't legal in terms of, at least in terms of the rule of law that they're doing. It's really sort of a cultural assumption that we make, and it's, I think it fits better with this notion of social contract in my mind. But nonetheless, I don't want to carry on too much. But those are the things that I think are relevant to the entry comments that Pam shared with us. So thank you.
And let me just say, I'm not saying the history is not important. I just think it varies, and I think actually Professor Nunn just articulated better than I probably could have. I think it buries the lead on the social contract piece because I agree, it's not a right. And when you present it in terms of the legal history, the frame up feels like that's where you're going. And actually, I'm put in mind of the Tackett case out of North Carolina, right? The provocation case. And if you don't know it, Sean, I'll send it to you. It's a provocation case where a formerly enslaved person tries to use a provocation mitigator and is told that it's not as inflaming to be spoken to for him to be spoken to in a certain way by a white person as it would be if the roles were reversed, right? It's the contract piece, in other words, right? I'll put the site in. It's a late 1800s in North Carolina, I think, but I'll grab it for you. Sean, do you want to respond to any of this or ask some follow-up questions before? I know Kenitra had some other things she wanted to add, but there's a lot we just threw out there for you.
Thank you so much, everyone. You know, I've only just started disseminating it to a few folks. And so some of the things you're naming, I am starting to get some feedback around, including the lead, which is really leading with where do we find ourselves? Because I think a big part of what I'm trying to do is a lot of things. The distinction between, say, like the idea that there's some distinction between private and public violence when it's a public officer versus a private agent. And so I think even starting more squarely in this place of January 6th, vehicular violence allows me to deliver a more compelling argument around, I think that this is a false distinction. I don't think that there really is much of a distinction between how the state is going to respond when it's a public officer engaged in violence versus when it's a private civilian. I think that there's far more commonality than there is distinction. So I appreciate this comment about leading more robustly with the vehicular violence with January 6th. You know, with regards to the right, I've only, I gave a quick overview. My biggest concern about using the language of right is, of course, that critical theory's primary contribution are that, rights are indeterminate, that they're just going to be subject to manipulation. And so am I really making this claim that we should understand this as a traditional legal right, that is recognized, explicitly stated, or has been explicitly stated since the abolition of slavery? But I'm having a hard time. I would appreciate some more feedback on what's not striking you all as persuasive about it being a legal right? Like I'm leading with, if you think of negative and positive rights, positive right is affirmatively fulfilling an obligation. Negative right is placing something beyond government intervention. I do see violence taking these forms. And so I think maybe just getting some more details about what's not striking you all as persuasive about that. And then maybe some details even, Kenneth, some more about if I leaned away from the legal right and more into this, how do these cultural presumptions inform our social contract, maybe a little bit more about how you think about proceeding with that.
So I think, Kenitra, I saw your hand up just toward the end there, and I know you had a question. Did you want to ask it now, or you want me to loop back to you? Because I also know Sean wanted some information from Kenneth. What do you think?
Okay. So I have a question. I have a comment and then a question to this question that I think will help me understand this question better. So the comment, it was really to the first part of the discussion, with more modern, with a more modern parallel to your historical comment, is that I would also think, if you're talking about a private citizen's right, I would also kind of include some discussions about self-defense and hold your ground laws, or stand your ground laws. Who's able to use them? Like, when are they allowed? And race, and this is where race becomes salient, because who's most allowed to use stand your ground defenses as an affirmative? I mean, and the color of the victim, color of the perpetrator, and self-defense. I think if you're moving it out of, you're saying that there's no distinction, but if you want to make the distinction between public acts by state actors and private citizens, that space could be a good one, particularly in this conversation, because if you recall, prior to the movement for Black Lives and Derek Chauvin, with George Floyd and Derek Chauvin, there's this other conversation that's happening around Zimmerman and Trayvon Martin. You've got a private actor there racing, and that's playing. That's a modern parallel that I think you might be able to play with at the top of your paper here. And then my question for whether we find, is the social contract or the positive or negative right more persuasive, what's going to help me think about that question is, what question are you trying to answer by asking about this? Like, what is it persuasive to? What's your argument here? I know we're talking about, adjusting these rights so that Black people feel more invested in the social contract or feel safer under the social contract. But what does it look like? Does it look like a removal of this, or does it look like an affirmative act by state actors to remove this negative right or this positive right to violence? Like that will help me determine whether, like, persuasive to which point. But can Professor Nunn may have more for me there, because that's my confusion.
I'll answer quickly. My argument, right, so this is again why I moved. It's breaking, right, it already, as I was presenting it to you all, I agree with you, Doug, around it's lifelong projects that I am articulating. And so it is a matter of giving myself space to breathe. What I'm building to is I'm both adopting Charles Mill's arguments, the racial contract, where he's making the argument that we have a global racial contract, and he was making this argument in the 90s, 80s, 90s. Where I'm leading is Black people are excluded from the social contract, and we remain excluded from the social contract, and that this is what the right of violence is representative of. And so I want us to be rethinking, how can we for the first time actually incorporate Black people into the social contract, and how do we get there? And then that will of course lead to some projects where I'm making arguments for abolition as our avenue for getting there. But yes, I would say that, like, my end goal is certainly not that I think that there's some reducible right that is going to solve the issue that I am naming. Nor am I saying that I think that there is some traditional legal intervention that's going to solve the problems that I'm naming. So I'm really getting at where I'm trying to build to, and the nature, right, is compromising the social contract. Have we ever had a racially inclusive social contract, and how does violence, its persistence, and the vulnerability of minoritized communities, how does this demonstrate that we continue to have a racially exclusive social contract?
Can I ask a follow-up question on that? Because hearing you describe it that way, I think as a reader, particularly if I'm thinking about it as a student reader, that context and understanding that this is a piece of a developing body of work where you're putting context on a much larger project would really, really, I think, be helpful to me. I mean, it's helpful to me now to think about this work not as a standalone, but as a piece of a project where you are really wrestling with not just how to characterize the issues you're grappling with, but why the characterization matters. I mean, because that's the other piece, is that I think just now listening to you, I began to understand why you started by asking, which is more persuasive to you than social contract or right, because it's less, I think I'm hearing you say it's less about answering that precisely in this question and more about building toward a comprehensive narrative and a comprehensive theory. And this is in some ways exhibit A in your demonstration of why that inquiry matters. Is that right? So I think if you can frame it that way, it would be enormously helpful, because the other thing that this does so brilliantly is you'll be able to, I think, capture people, well, like me, who are not strong in theory, but care a lot about the problems, right? So people who are who don't, for example, think a great deal about social contract theory, but who are instantly going to be struck by, yes, this is what violence against minoritized communities looks like. Yes, this is why white people were salvaging things after Katrina and Black people were stealing them, right? I mean, who will be able to immediately attach things onto your theory, and you're building here. And I think that's a beautiful thing to highlight as a scholar. Yeah, you know, at this point, like, just talk. Nobody needs to wait for me. You're muted. You're still muted.
Okay, now I can unmute, but I wanted to jump in earlier and I couldn't because I was muted, but here we go. So I think you answered the question you posed for me, Sean, with your answer to Kenitra. I thought that was I thought her questions were very probing, very, very good. And your response, you were saying, look, I'm not saying there's a discrete right that is going to guarantee safety for African descended people or other people of color. What you said is there's no discrete right, no legal intervention. So then the question is, what is left? If we're not using law per se as the mechanism for accomplishing what you want to accomplish, what are you using? What I would say is you're using culture. You have to change the mentality and the attitude of people who are going to see African Americans and Katrina stealing and non-blacks and Katrina salvaging.
Salvaging.
Right. So the bottom line is that is what has to be. And so, there's another example that I actually thought about writing a law review article about this. Is what strikes me about all of the January 6 prosecutions is how, and actually I don't want to say January 6. I want to say all of the prosecutions of people who were in the orbit of the former president. And I can't remember his name, but there's some guy who, they invaded his house down in South Florida.
Oh, yeah, the guy with the gun on the porch.
No, gun on the porch. I don't remember that. I'm talking about an advisor to Trump had his house raided. I can't remember his name. Okay.
Yeah.
But everybody was talking about, jackbooted thugs and this, that, and the other. And why did they go at X amount of time in the morning and all that? And as a person who's represented many people who've been subject to police, execution of warrants at their home, I was like, the guy got treated fairly mildly and they didn't trash his house after they went in there. So I couldn't understand. I mean, it's like all these things that people bring up where there's a vast difference in the way that people of means and people who have social connections are treated and the way that underprivileged people who don't have those things get treated. And it's just taken for granted. It's taken for granted and no one talks about it and there isn't really any concern about it. So I think that permeates not just January 6th, but really all aspects of the criminal justice system that we have. But we know on the surface, in terms of formal equality, the non-discriminatory character of our laws are there. And since the legislatures have been to law schools and they've been well educated by people like you, all right, they know that they have to write the law in a way that does not implicate 14th Amendment, and they're able to do that. So it's not the legal aspect, it's the fundamental understanding that, in the way I would coarsely put it, America is a white man's country. And what we need to do is we need to make sure that that is not disturbed. And if it is, people get really upset and they're going to storm Congress. So, I think all that's cultural in my view. One other slide point. What I remember the facts of State v. Mann is that it was a third party case. That is, it was a private actor who had rented an enslaved woman, and it was the owner of the woman who was suing him to get for damages because he shot her. So he was suing the person who rented the woman. But even in that context, the court said that because the person who rented had put himself in the place of the master during the time that he rented, his power, the power of the master has to be absolute, is a quote I remember from that case. And so I think there's, it's not simply a question in that case of state violence or state power against enslaved people. And it's not simply a question of, I think what you had said is something along the lines of it's, the person who gets economic value from them has the ability to use force, right? Well, the person who got the economic value is the owner. But even the owner's economic value, right, was going to be set aside to entrench and support white power. So anyway.
Okay, that's helpful. Thank you.
Shawnee, do you have, one thought that occurred to me listening to this is also that you're drawing from two very different bodies of law, right? There's a whole doctrine of property law, right, with ownership itself as violence, just period, and then the ownership rights that stem from it. And then there's another strain of law that you're pulling from. And I don't know whether it's helpful to think about those two different bodies of law, the criminal law versus property law. But I don't know whether that's valuable or not, but it's a stupid thought that just came in my head.
So I had kind of the same observation that making sure you're teasing that piece out, because it used to be women were property of their husbands or their old, male relatives. And if a woman were sexually assaulted, it was damage to property, right? Same concept in tort law. And tort law, of course, is foundation of criminal law. And not like doing homage to that, but at least making sure that they shift, right, from a property right to a property person for, whatever, when people, were viewed legally classified as property. I think it's worth at least noting it. And it might be interesting. I think an interesting point is like, did it make a difference, right? It's just kind of reclassifying, but then you just said like all the doctrines shift to get to the same place, right? How much of a difference does it make? And then I hope this is okay, just kind of, so just, I don't know, it's random or helpful. It might be neither, or might be random, unhelpful. I was just thinking, in terms of practicalities, we know that racism permeates our criminal justice system, right? It's just another extension of oppression. But it seems to me when we're talking about charging decisions or raiding houses or who gets sentenced, to me, it feels like mixing a lot of things. The outcomes are the same. And Pam and I do a lot of work in the front end part of the criminal justice system, which I actually consider the educational system, right? But thinking about that piece to the extent it makes a difference, and you can make the point like this shows up everywhere. But if the example is the length of sentences, that's one metric, right? One might be more prosecutors starting to develop and publish more data on charging decisions. And I do hopefully think that data is a great antidote to implicit bias, right? When we're faced with numbers, and that's why I like the work you're doing. It's kind of hard to argue with numbers if we're comparing the right metrics. So that's just a thought. You could give a little nod to work that's going on across the country. The one way to get at it is some of these data pieces. Now, it doesn't solve it, but it does put things out in front and at least like focuses the discussion. And so my last random point, I was thinking that it's not just the metrics of who gets charged, who gets rated, how the sentences are, but it's also, we know from the death penalty context, we have firm empirical evidence that you're going to get a higher sentence if you have a white victim. So it's not just who's getting charged, it's how we value, right, the worth we place on the harm to the person on the other side. So it's not just people who are justice involved as defendants, also people who are justice involved as victims. And that came out that the studies discussed well in George v. State. That's a Washington State Supreme Court case where they use the most updated data on that to invalidate the death penalty in the state of Washington. So you can find it there.
Great.
Okay. Sorry, that was a lot of randomness, but I'm really excited about your work and I'm looking forward to seeing it when it's public.
Thank you.
Hey, and Sean, just building on what Jordan said, I've thrown a link into the chat here. Somebody, I have not read it, but I remember seeing it when it came out. Somebody has purported to do some kind of empirical analysis of who was sponsoring and supporting these laws that would insulate drivers who drive through protests. I mean, I don't think it's an accident, parenthetically, that the driving through protesters becomes prominent during Charlottesville when there are good people on both sides. And then you see this rush of legislators seeking to protect folks who do that. But just to Jordan's point, I'm not vouching for the quality of this article. I have not read it. I just, I saw it. It came out, I think I don't know. It's a post Charlottesville, pre George Floyd article.
Okay,
So maybe it's helpful to you. I don't know.
great, I grabbed it.
Okay, good. How else can we, I mean, how else can we help you and help you think about this? It's a terrific project.
Yeah, thank you. So your feedback, some things that are especially sitting with me, obviously about changing the lead, I think being clearer about that I don't have to hide my hands around this is a building project. I agree with you that if I can lean more into that, it will make this feel more manageable, because I agree with you, Jordan, about some of the things that Jordan said, Kenitra, what you also pointed out, I actually do have in the piece right now, which is about how often justifiable homicides are ruled justifiable when the victim is Black. Overwhelmingly, if the victim is Black, you have about a 238% improvement on it being ruled justified as compared to when it's a white victim. Jordan, to your point, I'm talking about criminal sentences, criminal charges in the context of, sexual violence in prisons in particular, right? So I do get into these things as to preface I'm going to drill down into January 6th and vehicular violence, but that we should be looking at all of these other iterations of the right, in my opinion, as such. So really, agree. I think, Jordan, you're spot on with just, saying again more clearly, this shows up everywhere. Here are these metrics that we can use. I'm going to direct your attention in these ways, but these can also be other, because I do want I have a lot of goals, but part of my goal, even to your point about, women being particularly the victims of their spouses, of being victims of domestic violence, and that a big part of what feminist scholars were pushing back against, and Robin West has emphasized for me, is this public-private distinction was used by the state in order to justify violence against women within their homes, right? That this was private violence that the state merely could not reach. So I do want my reader to have as a takeaway that you can apply this conceptualization of a right in myriad ways. I am looking at it along the axes of race and class, but I think that there are myriad other axes that someone can use. So I agree that, I want to read some just more feminist literature, particularly around domestic violence, because I think that would be helpful here. And so I guess maybe my final question is, I'm going to give some more thought to social contract versus legal right. Maybe these are not, at odds with each other, right? The social contract contains legal rights. And I just have to think through, but maybe if folks could end with, what would you want to have, or what did you have as the core takeaway of the piece?
Great question.
Right now, based on my
Hot
opinion, what
take.
would you
Okay.
say you were like the most excited, or what you took away as the core piece?
When you presented, or since we've talked?
Let's say since I've talked too.
Okay. I go first. So what I took away was, you have this very ambitious project about excavating and grappling with the cultural and structural reification of white supremacy as an instrument that is legalized violence, as well as kind of culturally sanctioned, in part because it is made, it is made invisible in some ways, right? We don't see it, right? We've become, this is the Katrina example, right? The language, the culture piece, that you have this very ambitious project, and that this is, to me, what I heard is the first building block in saying one way to look at this project, one way to look at this problem is to ask why in this moment of enormous national division and national crisis, we see these two very similar kinds of conversations happening with you know, and yet with very, very different outcomes that are clearly racialized. That was my big takeaway here.
I have a suggestion and my big takeaway. I think it may help when you're framing or when you do discussion. You briefly mentioned this, but I also just wrote this out and thought that, that would be helpful. You mentioned the right to privacy. It's not explicit in our rights. It's understood. It's an implicit, it's an implication based on all these other rights. And you went into that, I think, like, for people when they're reading it as a parallel, even if you just take a paragraph to say, there's no explicit, well, the right to privacy wasn't explicit in the Constitution and all these things. It's an implication from all these other things. If you start with like literally that and say, this is my argument, like this right to violence is, again, there's no explicit right to violence in the Constitution. This is what we've driven. This is what's come from the implication. I mean, there's a right to protect, to, you know what I mean? Like, there's a way
I think the 13th Amendment is a right to violence.
Ooh,
Mm.
I will stop there because I need to sit in that for a minute. But I think it does as a parallel to help people who are thinking about what you mean by this framework of the social contract. Like, what do you mean? Or who are thinking about it. The right to the right to privacy is not an explicit right. Explicit, it's not itself. You have this right. It's this penumbra of other rights that make the implication. I think you do the same thing here. And that's what I came away with. There is like this, you're not theorizing. Like this is where we're coming away with. We've got this set of case law or rights in this country that makes violence a right. And it's confusing and I think that could help with the framing, at least for me, because I'm still wondering, I think I come out wondering, well, what's the recommendation that you have? Is it that Black people are included in this right to be violent, or that white people are taking out of this right to be violent? Like, what's like the ultimate, not this paper, but either in this paper or in the line of papers that follows, what rights, what then do you want us to do? All right, do Black people become part of the social contract by this right to be violent? Or do we remove it and, like Professor Nunn said, completely change the cultural context?
Great. I don't know if we're at time or not.
Well,
We have 5 more minutes.
I would
It's
just
yours.
say, if I can do so quickly, I think that you've got a very impressive project ongoing. I like what you're trying to do, and my takeaway in terms of what you're trying to do is you're trying to say, look, there's this unspoken aspect of the way we apply legal rules in the criminal justice context. And that is something that is very deep and goes very far back. And it has to do with whether or not the violence at issue that should be controlled by the criminal justice system through its use of violence, rather that what is the purpose of the violence? And when the purpose of the violence is one that is socially approved, then the system either can't handle it, or they ignore it. And that was what I got away. That's what I got from your presentation. And I think those are core points That's the kind of thing that people are not talking about, and that's what makes your contribution valuable in my mind. Thank you.
Thank you.
So Sean, we're at 12 minutes after the hour. This is obviously recorded and we'll give it to you. Part of the reason we do that is because it's so hard to listen and take notes at the same time, and there's so much content coming at you. Before we close out, I want to remind folks that we do have a full slate of upcoming events. We'll drop a list in the chat. If you're on the Zoom and you have not already done a work in progress with us, please feel free to send one. We take ideas at all shapes, including the just spitting stage. We're good with that too. We love to have you and your ideas. Thank you so much for joining us. Sean, I'm more excited about this, what you're doing right now, than I was when you started, because I like to think about this as an ongoing project. Like the idea that there's more is very, very exciting.
Yes,
So
thank you all so much. I really appreciate the feedback and maybe following up separately.
Yeah, please feel free. I can't volunteer everybody else, but here at the Deason Center, I know that we're always available, and we'd be happy to, spitball with you. And again, if you want to talk about some ways maybe to make a little chart or something that would show, kind of really visualize what you're talking about, happy to help you with that also.
Okay, great. Thank you.
So thank you all so much, and we'll look forward to seeing you in February. Next event, we'll be talking about marijuana prosecutions, non-prosecution policies, declination policies, and racialized enforcement of marijuana laws. Thank you all so much. Bye-bye.